Did you know that you can file a trademark application before you fully launched your business to basically call dibs on something that you want but aren't quite ready to use yet? These types of applications are known as intent to use applications, and there are some important things you should know about these special applications before you file one. Hey friends, welcome back to my YouTube channel. I'm Faith Mitton, an attorney on a mission to simplify trademark law for entrepreneurs and business owners so that they can better understand their legal rights. Here you will find tons of easy to understand content to help you learn how to navigate the crazy world of trademarks and to stay on the right side of the law. Let's start today's convo by defining what a trademark is so that we have a good foundation to build on for everything else we'll talk about in this video. A trademark provides legal protection for the brand identity of a business. The things most commonly registered as trademarks include things like business names, taglines, and logos. Although there are also non-traditional trademark registrations for things like building designs and product packaging and colors and sounds and scents and even more. And while state governments do individually register trademarks, the better option is to register your trademark with the federal government through the United States Patent and Trademark Office or USPTO. This is because state trademark registrations will only protect you in the states where the trademark is registered, whereas federal trademark registrations will provide protection for the entire country. And that means with a federal trademark, you can shut down trademark infringement regardless of where your competitors are located in the country. But as a US-based business owner, you have to tell the USPTO whether you are applying for a trademark that you have already begun using or one that you want to use in the future. The term filing basis is used to describe this concept legally. So if you are applying for a trademark that you are already using, you would apply for your trademark on an in-use filing basis. But if you are applying for a trademark that you have not begun to use yet, you would apply for that trademark on an intent to use filing basis. By using the trademark, I'm referring to use in commerce, which is one of the most important requirements for federal trademarks that are reviewed and approved by the USPTO. Use in commerce is something that I have a whole separate video about because it's a pretty complicated topic. But for now, I'll summarize it by saying you must be selling your products or providing your services under your trademark in a way that has a reach outside of your state in order to establish use in commerce. I'll tag my use in commerce video here and link to it in the description because you should check that video out if you are even remotely interested in applying for a federal trademark, because you will need to understand this concept in order to navigate the federal trademark application process successfully. But if you're watching this video, you're probably doing that because you haven't started using your trademark at all, let alone in commerce, and you still want to know whether you can apply for your trademark and what the process will look like for you. So let's talk about that now. Intent to use applications are important for scenarios where you haven't publicly launched your brand yet, but you still want to make sure that no one else grabs the name, tagline, logo, etc. that you plan to use. Filing these types of applications can block the approval of any later filed applications for similar trademarks by your competitors, even if you have not begun using your trademark yet and your competitor has begun using the trademark. So it's a really good way to keep your place in line. With an intent to use application, you're not required to make any legal filings to set up your business or submit a business plan showing that you intend to launch a business in the future. All that is required is that you have a bona fide intent to use the trademark in the near future, and you will need to sign a legal document affirming your intent to use the trademark as part of submitting your trademark application. When you file an intent to use application, there are two potential avenues for your trademark application to take. The first track is the typical one for these kinds of trademark applications, where you file the application without submitting a specimen, which is proof of use for how you are using the trademark, because of course you haven't begun using the trademark yet, so there's no proof of use to submit. There are many things that you may be able to use as a specimen when the time comes, but screenshots of your website where your trademark is very prominently featured in close proximity to the products and services listed in your application are most commonly used as specimens for trademark applications. But you won't have to worry about submitting a specimen for a pretty long time, because after you submit your application to the USPTO, it's going to take several months for the USPTO to even assign an examining attorney to review your application. And then once your application is assigned to an examining attorney, there's a pretty good chance that you might receive something known as an office action, which is a temporary rejection of your application from the USPTO because it has failed to meet some sort of legal requirement. Office actions are a really common part of the trademark application process, so you shouldn't panic too much if you get one. However, if you do receive an office action, you must reply to it and overcome it in order for your trademark application to stay alive and to move on to the next phase of review. Resolving office actions can take anywhere from 3 months to 6 months, or maybe even a little bit longer, but not all applications receive office actions. So if your application does not receive any office actions, or you are successful in overcoming any office actions you do receive, the next phase is publication. This is a 30-day window where the USPTO allows anyone to challenge your trademark application by filing paperwork to start a special type of lawsuit known as an opposition. Oppositions can take anywhere from a few months to a few years to resolve, although they are much less common than office actions. But still, like office actions, if you receive any oppositions to your trademark application, you must successfully defeat the opposition and resolve it in order for your trademark application to move to the next stage. If you resolve your opposition successfully, or if you don't receive one, which is the more ideal situation, then at this point, the USPTO will ask you finally to submit your specimen or proof of use of your trademark. This request will come in the form of a document known as a notice of allowance. And there is a 6-month deadline to respond to the notice of allowance with a specimen. If you haven't begun using the trademark by the deadline, no worries. You can file an extension for another 6 months by paying a little fee to the USPTO. If the second 6-month period is coming to an end and you still haven't begun using your trademark, no problem. You can file additional 6-month extensions all the way up to 2.5 years after you have already used the first 2 6-month periods. That means you have a total of 3.5 years to begin using your trademark after a notice of allowance is issued. And by that point, you're already well over a year into the trademark application process. So you have a long time, and that's perfect for situations where it might take you a while to get your business off the ground. But remember when I said just a few minutes ago that filing intent to use applications can block any later filed applications for similar trademarks by your competitors, even if you haven't begun using your trademark yet? That is only temporarily true while your trademark application remains alive and active in the USPTO database. Your application will not be able to block any later filed applications once it goes into abandoned status because you didn't file the appropriate specimen within the required time frame or didn't make the appropriate extensions within the required time frame. So just be mindful of that. Even with an intent to use application and with all the potential time that you have to begin using the trademark, you still have to monitor your deadlines and make sure that you make any required filings when due. But now let's switch to the second track for intent to use applications. This one is much more streamlined than the first option. With this one, you would file the trademark application as before without filing a specimen, but this covers a scenario where you are able to establish use in commerce by selling your products or providing your services under your trademark in a way that has some sort of reach outside of your state prior to publication of your trademark. If that happens, you can make a quick filing with the USPTO to say, hey, I'm amending my application from an intent to use filing basis to an in-use filing basis because I want my trademark to be approved, hopefully, more quickly. And when you make that filing with the USPTO, you'll also submit your specimen showing proof of use at that time, so that once publication of your trademark is completed, and hopefully you don't get any oppositions or you successfully resolve those oppositions, then your trademark application should be approved at that time. And regardless of whether your trademark is on the first track, which is longer, or the second track, which is more streamlined, you might be in a situation where you begin using the trademark for some things listed in the application, but not all. If that happens, also no worries. You can make a filing with the USPTO to divide your application, and that way you can separate your in-use products and services from the ones that you haven't begun using yet. And this may be able to help you to get approval for your in-use products and services more quickly while you work your way into putting the other products and services into use. And that's a wrap. Now you know that you can apply to register a trademark for a brand that you haven't publicly launched yet by filing an intent to use trademark application. These applications give you the option of protecting your brand by blocking any later filed trademark applications for similar names, taglines, logos, etc., while your trademark application is live and active in the USPTO database. With intent to use applications, you may be able to keep your trademark application alive for years prior to providing the proof of use in commerce that is required for federal trademark registration. And remember that use in commerce refers to selling your products or providing your services under your trademark in a way that has some reach or impact outside of your business's home state. If you enjoyed this video, please give it a thumbs up and be sure to subscribe for more trademark content and to turn on notifications so you never miss when I post a new video. If you have questions or thoughts to share, I welcome you to put those in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you as always for watching, and stay tuned for the next video.